Hey folks, welcome back to the Law and Crime Network. I am Michael Bryant. You know, I mentioned we have a special guest for you, and I do. This is a gentleman you might recognize. He's been practicing law for 30 plus years, 230 jury trials. He was lead counsel on 22 homicide cases, and more recently appearing on Law and Crime Network back in June for the first round of the case in which he represented this gentleman, Kellen Winslow. Marc Carlos joins us now live from the San Diego area. Marc, thank you for joining me. I appreciate it.
Sure. How are you?
I'm doing great. I'm sure I'm better rested than you are after quite the week that you had there. Let me tell you, I was sitting in this chair Monday afternoon about 4:30 Eastern time. We were waiting for the opening statements in the second round of the case against your client, Kellen Winslow. And it was not to be, but it was the most dramatic non-trial that I've ever either witnessed or taken part in as an attorney. I've got to ask you this first question. As you're sitting there, you've just spent time with Mr. Winslow going over these possible plea arrangements, and it's now playing out in front of the court. He's being asked questions by the judge, and there are some painful silences, some very loud silences. What's going through your mind when your client is being asked, A, if he's going to waive his jury, B, does he plead guilty to these charges?
Well, I mean, there's a lot that goes into it. First off, I mean, as you can probably see, it was a very, very stressful situation. I mean, the case was highly publicized. There was a lot of discovery to go through. Mr. Winslow was one. He has a lot to lose, and in this particular case, he was looking at potentially like 70 to life in prison should he get convicted of any of the multiple victims. So there was a lot that went into his decision to plead. Kind of truly, I mean, I've been doing this 30 plus years, and I have really never had a situation where there was an appellate issue that was so strong where we were waiving the appellate issue was probably the biggest concern for Mr. Winslow. I mean, it's something that I think that weighed heavily on him because he felt that he had a pretty good shot at that. But, you know, if he went down on any of these victims, he'd be getting a life sentence. And if he lost an appeal, he'd be stuck with that life sentence. So for that reason, you know, he decided to move forward.
And that leads me to this question. You know, it seemed that he was hesitant to say, yes, I did it. Do you feel that Mr. Winslow is remorseful at all for what happened?
Well, you know, you have to, it was really, once again, really stressful. Can you imagine? Mr. Winslow's been in custody now for approximately 10 months. This is a guy who's never been in jail. He's been an athlete. He's been somebody with a lot of money. And so to be put in, essentially, he's almost like in solitary confinement in the jail because he's high profile, keep away. So he doesn't get a lot of interaction. So that, coupled with, you know, the allegations, coupled with all of the cameras and all kinds of media coverage, made it really difficult for him to express his remorse. He was more concerned really about what was happening and whether he can grasp, you know, the proceedings, which I believe that he could. I mean, he understood what was going on. He understood what he was giving up. The judge was, you know, it may have seemed like it was a bit pushed, but, you know, he gave us about 2.5 hours of courtroom time. He just gave us the whole courtroom. He even allowed his father to be there and his mother to be there while we discussed the ramifications of a plea. We discussed, you know, what would happen at trial. You know, so it was, you know, you couldn't tell what was going to happen until the actual time where he was entering the plea. As you can see, we had several discussions with him during the plea colloquy. He was asking questions. I know it definitely was a very stressful situation.
I can imagine when you heard him say to the judge asked about taking the plea, and he says, "I guess I have to, Your Honor." What was your thought at that point?
I thought the plea was going to get taken away. You know, in California, you can't really. I mean, if you can't enter into a West plea, which is basically a plea to take advantage of a plea bargain, but that has to be essentially agreed to by the prosecution, and they weren't agreeing to that in this particular case. So it had to be a guilty plea. And if he wasn't going to accept responsibility, then the judge could actually refuse to take the plea and then move forward in trial. And, you know, everything that he said, everything the judge said on the record was actually true. We had 16 jurors. We had 12 jurors and 4 alternates out in the hallway. We had all of our opening statements all loaded up onto the, onto the projectors. We were good to go. You know, this whole thing really just took place off an offhanded comment that we had with the prosecution, and then it just sort of blossomed from there, and it took place over a short period of time, so it was pretty rushed.
Yeah, so how so? Fill us in on how that all evolved because, you had new counsel brought in, Brian Watkins left, and Gretchen Van Helms came in. What was the change in the dynamic there, and what exactly was it that spurred the plea discussion?
Well, it's okay. So the couple things, for your viewers at home, or people who watched the first trial, Dan Owens is, it's not a stereotypical type of thing. I mean, he was a very, very pleasant individual to work with. He was very very fair-minded. And so he had a lot to take into account regarding, his victims in this particular case. As you remember from the first trial, they were vigorously cross-examined, and it wasn't going to get any better for them the second time around because we had trial transcripts, we had preliminary hearing transcripts, we had, we had body wire camera. So they made a huge number of statements which they would have been cross-examined on, and that's basically what I do. I mean, I cross-examine, and that's my skill essentially. And it would have been really, if you've ever been through a sex crime, it is very traumatic for victims to go through, and it's something that they have to deal with, for quite some time. And so he took that into account in, trying to find some sort of closure. And for that reason, when we proposed, hey, could, we used a really low number, could that close this out? And he said, no, you got to come up a little bit. And then that's what started the whole kind of back and forth. And then we had about 25 minutes to deal with it on a break. And then we told the judge we needed just a little bit more. The judge gave it to us, because it would have been a 4-week-long trial, cost the county and the state of California, a lot of money to go forward with it. So in the end,
you basically added a ninth charge to take over for the 3 charges as to Jane Doe number 1. So it was a sexual assault with restraint. It seems to be the goal was almost to get to a certain number of years that everybody could choke down and feel like justice had been done.
That's what plea bargains generally are. I mean, plea bargains are give and take between the parties. If there's something that you can use to your advantage, like in our case, it was saving the trauma to the victims as well as giving up his appeal. That was our bargaining chip, and their bargaining chip was you go to trial and you get convicted and you are going to go to prison for life. And it was about 50 plus years to life, and in California, life means life. So Mr. Winslow would have been, Mr. Winslow Sr. would have left this earth knowing that his son would have been in prison for the rest of his life, which is a horrible thing for a family and for a father.
Had you gone to trial, would Kellen Winslow have taken the stand in the second go-round?
That's a decision that trial lawyers make as the case is going on. The first time we tried the case, that was our plan because Kellen is a very, very articulate individual. He's really well spoken. You kind of get drawn to him. I mean, I've had quite some time to get to know him, and he's a very, very charismatic individual. So our plan was to have him testify. But as the case sort of melted down around the prosecution's case, the first trial, we decided that it was in his best interest not to testify. So the second time around, that's something we held in our back pocket, the decision as to whether or not to put him on the stand. We prepped him for it. He was ready to go, and that was the last sort of, that would have been the emotional kind of icing on the cake at the end of the trial. It would have been something that we made the call like the night before.
So, Marc, before I let you go, quickly, first of all, how is he doing? Is he emotionally hanging in there? Is he on suicide watch? Is he getting ready for the sentencing in February? And what do you plan to put on in terms of evidence to get him the best end of that 12 to 18-year range?
Well, so he is doing well. He's doing a lot better than he was actually leading up to the trial. Like I said, he's essentially almost in isolation. And the plea sort of gave him a little bit of finality too, where he's able to see a light at the end of the tunnel. I mean, he knows there's a number that he has to get to in order to be released, and he's fine with that. Now he's sort of resigned to moving on to the next stage. So for our purposes, we were not able to bring on evidence of CTE, any type of frontal lobe damage during the trial because it wouldn't be admissible as to the general intent crimes of rape. So there's a chance that he has been evaluated, and as you probably know, there's no way to diagnose whether somebody has CTE while they're living, only when they're dead. But he may have symptoms which are consistent with the early stages of it, which may shed some light as to why he may have acted the way he did under certain conditions. And so that in combination with the psychological evaluation that we've had prepared, and as well as character and statements from the family. Those are the things that we'll be presenting, because nobody's presented a picture of Kellen Winslow other than just these horrible allegations. And so, we need to do that to convince a judge to bring the sentence down.
And you'd already done the one evaluation. Will there be another one pre-sentencing done either by you or independently?
Yes. I mean, nothing gets done independently. It's the defense will present it. So there's a number of evaluations we need to go through in order to determine which ones that we're going to submit to the court. Because what you should understand also is that there is the backside is he is subject to sexually violent predator treatment at the end of his sentence. So he will be evaluated by the Department of Corrections. And so we need to be able to present psychological profiles which can be useful when that actual evaluation takes place and the decision as to whether or not to release him takes place.
Okay, one more question. I know he's been in custody all this time, but being in custody pending trial, during trial, very different than when the sentence is handed down. Have you prepped him for what that life's going to be like for a celebrity of his status?
Well, yeah, I mean, there's like experts that can come in and kind of talk to them about, this is what happens in the Department of Corrections, this is where you go to, this is how you do things. I have several of my higher end clients, in both federal court and state courts. We give them sort of a lifestyle expert for the prisons, people who haven't been there before. So it kind of eases the transition from for him, county jail, or if somebody out of custody, into an incarcerational facility.
Okay. Well, thank you, Marc. I appreciate the time. Great work there. Everybody on the table, everybody out there watching appreciates the effort you put into this case, and really a tremendous defense, ultimate defense resolution to this matter. So thank you again, and we'll see you in February for the sentencing. Good luck with everything.
Okay. Thanks.
You
Bye.
bet. Marc Carlos, Kellen Winslow II's attorney. We will be right back to Law and Crime. Stay wherever we are.